Okay, still hearing testimony from Eric Knight. He is a friend of the victim here, Jordan Edwards. Rory Oliver, a police officer in Texas, is on trial right now for his murder. He was 15 years old when he was shot and killed just a few years ago. Joining me right now in studio is Brad Micklin, and via Skype all the way from Atlanta, Georgia, is Ashley Willcott. I want to get right into this, and Ashley, I'll toss to you first. I pulled up the use of force policy here for this Balch Springs, Texas Police Department. And listen, I'm a former police officer. I know the use of force policies, but they do vary from state to state, department to department. And it says law enforcement can use deadly force when there is a imminent fear or belief that there's a threat of serious bodily injury or death. Now, this officer, Roy Oliver, is saying that the car that was leaving the scene attempted to strike him, which you can see the video there on your screen prior to that shooting. But it also says in this use of force policy, firearms shall not be discharged at a moving vehicle in an attempt to disable the vehicle. So it's kind of twofold. He says, and it's up to his articulation, his reasonable expectation here that that vehicle was trying to run him over. But when you look at the video, do you see that there was an imminent threat against his life? And if not, then he did violate policy by firing into that vehicle, Ashley.
I do think he violated policy by firing into the vehicle. Take that in conjunction, Vincent, with the testimony we just heard from the eyewitness. He specifically testified, number one, that he did not think shooting into the car was justified. And then he just testified that he said to his mom, wait, I wrote down the quote. That's not right. That car wasn't traveling backwards. So I think there's some facts that would, A, support there was no imminent threat, but B, I still don't think he should have been shooting into the car under the policy.
Now, Brad, listen, I've done these things, these high stress situations before. Now, police had a right to be there. There was some shooting going on. So, of course, they had a 911 call about some kids, loud music, whatnot, shots ring out. I can understand why the officer ran to the car. But we had testimony from the previous officer that says he didn't feel that the vehicle was trying to get him. What do you think about that? Do you think that's bad for this defense?
Well, the testimony that his partner didn't fear for his life doesn't help. But the question really is what was going on in the defendant's mind. Was his understanding and actions reasonable? Now, they're going to use the partner's testimony to suggest that it wasn't. The prosecutor's going to use it to suggest it wasn't. But, you know, we have a high tense situation. You know, we have the body cam footage where he's saying right after the shooting, are you okay, which either was very contrived and planned, which is unusual given the highest tension, or he really was familiar with his actions and the problems it could have led to. And I think that was part of my research suggested that Officer Oliver may have previously had a similar instance where he fired into a moving car. Now, I don't think the jury's going to hear about that, and I'm not really sure what the outcome was. But that could have influenced his actions here, and which is why his body cam shots, he talks about his partner being safe, because he knows at the moment what he did may have been unjustified.
Yeah, and, you know, again, I've been in these high-stress situations. There's a lot of split-second decision-making in policing that, of course, when this goes to trial, a lot of people question those actions. I don't want to Monday morning quarterback his actions. I can just say from what I saw, I don't see where that vehicle was a danger. We're going to get back in this courtroom right after this break. Stay tuned here on the Law and Crime Network. Don't go away. Thank you for that, Anthony. Still with me, Ashley Willcott. Ashley, we just heard that story there in the barbershop. Look, the world was shocked, definitely yesterday, with the death of the Queen of Soul, Aretha Franklin. I can tell you my dad had so many 8-tracks and albums of the Queen of Soul, Aretha Franklin. But, you know, I just don't get this barbershop incident. Listen, I go to the barbershop every time. I was just there yesterday trying to get like Jesse and Aaron, get my hair straight. But I don't think that I would get into an argument so much that I would pull out a gun and shoot someone because I wanted Halle Berry to play Aretha Franklin. This is a crazy story, Ashley.
Yeah, it is a crazy story. And so I guess I would suggest that this person might have committed a crime, whether it was about Aretha Franklin or not, because certainly everyone's been mourning her death and celebrating her life, and that's not a way to do it. So it's sometimes you really can't defend or explain criminals' actions for certain.
Yeah, I don't know what the defense in this would be. I mean, when you go to court, and I mean, you're a judge, you're a trial attorney. When you go to court, as a defendant, what do you say? Well, he disrespected Aretha Franklin because he wanted such and such a player. I don't think that's going to go too well with these jurors. What do you say?
I would absolutely agree with you. I think they're going to have a hard time coming up with a good defense in this case.
Yeah, absolutely. Respect. That's what that guy should have used right there. Find out what it means to me. We're going to switch gears here and talk about Shayna Hubbard's. Of course, our own Aaron Keller has been covering that from that Kentucky courtroom all week. The judge has given us limited access to that courtroom, but Aaron's been there all week reporting on that, covering that. So we want to switch gears and hear from Lawrence Pilcher, the state police firearms. Now, again, Shayna Hubbard's was already on trial. She shot her boyfriend lover in the 6 times, 1 in the face. She claims, of course, it was self-defense, but she was previously on trial, but unfortunately, one of those jurors was a convicted felon, so she ended up getting a new trial based on that. So let's take a listen to this Lawrence Pilcher, the state police firearms examiner. Motion hearing going on in that courtroom on the Roy Oliver murder trial. Again, he's a police officer in Texas on trial for murder right now, and you heard the prosecutor there say he gave 2 different stories. He said one, that he thought the car was trying to leave the scene or evade the scene, and then the other that he thought they were reaching for something, is presumably a gun, because we heard gunshots just before Jordan Edwards was shot. Still with me in studio, Brad Micklin, and still with me via Skype, Ashley Willcott. Brad, I'll toss to you on this. How important is it that if this officer did say he heard 2 different, or he stated 2 different accounts, I don't think that really looks good for him, because if things are the same, your story shouldn't change at all.
Yeah, I don't think it's going to help him at all. First, because there's a very good chance he doesn't testify. So if he doesn't testify, this is all that we're going to have for the jury to hear about his side. And if there's a conflict in what he says, and he's changing the story to best suit his actions, it's going to hurt when the jury tries to determine what was his intention. Did he act in good faith or the best course he could have?
Right, absolutely. And again, listen, I've been there. I know those split-second decisions, but it's up to what an officer believes is reasonable at that time. That's what this officer has to convince this jury of. We'll be right back into this Texas courtroom right after this break here on the Law and Crime Network. Stay tuned. Okay, so there you see it. The judge has denied another motion yet again today. I think there's been several motions throughout this trial today that the prosecution and the defense, or the defense rather, has tried to get through to the judge here, but he's denying him left and right. We see a new witness taking the stand. Still with me, Ashley Willcott, and here in studio, Brad Micklin. This case is really heating up, but Brad, you and I were talking during this whole thing, and it's not as easy as people assume to charge a police officer with murder, right? Because police have a legal right to be there, i.e. they had a 911 call about the loud music, then shots were fired. So this is not an open and shut case as many people would assume. What say you?
No, I agree. We have to keep in mind we're sitting here after all this happened. We know there were no drugs supposedly there. There were no weapons supposedly there. But the officers responding didn't know that. All they knew was they were going to a house with 200 or 300 kids or people. They hear gunshots. They see people fleeing. They see a car leaving. And the important thing that a lot of people that write and comment about this haven't really considered is the gun law in Texas is very liberal. See, we're sitting here in New York. I'm from New Jersey, and we have very strict gun laws. So we assume the people that we talk to don't have guns on them. But in Texas, my understanding is if you're 18, you can have a gun in your car that you own without a permit.
Right.
So this is what's in the officer's mind when he's chasing this car. That they could legally have a gun, and he heard shots fired. So I think his actions are more reasonable than it may seem when we sit here in hindsight.
Absolutely. It looks like that witness is being sworn in Virginia. Is that right? Or okay, we're still waiting for the jury to to come in here. Ashley, Brad made a good point, and one of the key things here is the officers did not know there was not a gun in that car. Everyone keeps saying that no guns were recovered and Jordan Edwards wasn't armed, which is true. But again, when you look at the circumstances leading up to this, there was shots fired. You see this car leaving the scene. So a reasonable officer would presume, or assume rather, that there could be guns in that vehicle, especially after the officer had given many verbal commands to stop the car. So again, it's not as easy as people assume that, yes, this is an open and shut case when you have to add in all those factors. What say you, Ashley?
Well, I agree. And again, it's the reasonableness from that officer's standpoint. But keep in mind this, during some of the motions hearings that we've been listening to, they're talking specifically about the mens rea, the intent. And so they're discussing what evidence should be allowed in to prove that he had the intent to commit the crime as well as the action. And so that's another piece that goes along with whether or not he thought it was reasonable. Did he have the intent to commit this crime or not?
Absolutely. All right, the jury's back in. The witness is on the stand. Let's go into that courtroom. Wow, so you just saw pretty dramatic testimony from Maxwell Everett. He was in the car the night Jordan Edwards was shot and killed. You heard he actually thought Jordan had spilled his drink, his red drink that he had purchased earlier in the night, and then he realized it was not the drink that Jordan had spilled. It was actually the fact that Jordan Edwards had been shot in the head by Roy Oliver, who is on trial right now for murder. Still with me, Ashley Willcott from Atlanta, and with me in studio, Brad Micklin. Ashley, I'll toss to you first. As a judge yourself, and having been in many of these trials, like that testimony right there, I'm sure it touched a lot of jurors to think, oh, I thought my friend spilled his drink, but yet it was his friend's blood.
Yeah, and it's not only that part. Let's talk about jury impressions. This witness, I think, Vincent, is very credible, very believable, very real. You know, he got the humor of the jury when he starts talking about the mosh pit where they were dancing and indicated what that meant. And so I do think that this witness is very credible, very believable. And so it really pulls on your heartstrings when you hear him then say, I thought he spilled his drink, and break down on the stand. You know, it's just, you can't even imagine what it must have been like for him to be in the car when this shooting occurred.
Absolutely, and Brad, so, you know, we saw that young man crying there very heavily there in the courtroom, and one of the questions he was asked, were you in fear of your life when the shots rang out? And I assume he means the shots from police officer Roy Oliver.
Right, and you know, that's the hardest part about this case, is that the victim is completely innocent. There's no allegation that there was anything they were doing wrong, except for maybe fleeing, but that's understandable. There's gunshots, there's police, he's a teenager. Any of us would probably do the same. It begs the question of really what is even the relevance of having this witness, other than to sort of pull on the heartstrings of the jury, because there's no question that the officer shot Jordan. Right. So what his friend saw, what his friend felt in the car really has no relevance to that.
Yeah, absolutely. And one thing I do want to point out, you heard some of the line of questioning about him being pulled out of the car and placed on his knees, his hands behind his back. Now, let's be clear, in the interest of fairness, that is all protocol anytime you believe that there's an imminent threat. We did hear gunshots. Police had just shot into this vehicle. They assumed there was a gun, someone armed there. So that part is protocol. But to Ashley's point, to see that jury there, or to see that witness there before that jury crying because he realized his friend was dead, basically just a few feet away from him, is very traumatic for any kid to have to deal with. And especially for the jury to have to watch that. I can only imagine what they were thinking. If we could actually pull up the body cam video, you see the video there on your screen. This is just before the shooting. If we can get that back up, the car there that Jordan Edwards was in, you can see it backing up. This is when the officer was giving commands to stop the car, and let's look at how quickly this escalates to gunfire. Right. The shots are being fired into that car, and I always say, anytime I'm talking about police cases, things can escalate within a split second. But again, it's up to what the officer believed to be reasonable at that time. Did he believe there was an imminent threat against his life? Let's actually watch that clip with the sound so you can get an idea. Thank you so much for that, Anthony. Still with me in studio, Brad Micklin. Brad, all I can say is R-E-S-P-E-C-T. I mean, you get shot because you think Halle Berry should play, and this guy doesn't think Halle Berry should play. I don't know how that's going to play out in the courtroom, but, I mean, that's just, in my opinion, a very stupid shooting. You can't claim self-defense. You can't claim anything.
Yeah, it's really surprising, and we hear all these wild gun offenses, and again, like we were talking about with Texas, this, I believe, happened in Virginia, which has even a broader gun law. I think in Virginia, you're allowed to openly carry without a permit.
Right.
So I think part of the reason we're seeing these types of crimes is maybe, and I don't want to draw a big political debate, but could be partly the gun laws. But also, I understand that both of the victims, or both of the individuals in this incident, are hospitalized. So it suggests that there may have been a struggle before the shooting. So I'm not really sure yet what happened.
Yeah, it's a strange situation, to say the least, that this is what the world has come to, that you would get shot over debate of who should play who in a movie. I can think of few people that should play Aretha Franklin, but Halle Berry probably wouldn't be my first choice. But that's just me.
Well, don't let her hear that.
Right. All right. So we want to switch gears here. Of course, we've also been covering the Shayna Huber's case in Kentucky. Now, she has previously stood trial, been convicted of killing her lover, her boyfriend. She shot him 6 times, 1 in the face. You can see her there on your screen. But the problem is, one of the jurors in her previous trial was a convicted felon. And as you know, you cannot be a convicted felon and serve on any jury. So she has a new trial going on right now. Our very own Aaron Keller has been in that courtroom covering as much as he could because the judge will not allow live streaming for that trial. So we want to switch gears, talk about that case. We want to hear testimony from Lawrence Pelcher, who is the state police firearms examiner. Let's listen to his testimony. Okay, that's pretty crucial testimony there from Lawrence Pelcher, the state firearms examiner for the state of Kentucky. Now, still with me, Ashley Willcott and Brad Micklin. So you just heard that testimony, Ashley, about the distance between the gunshot and the victim. And I think that's actually pretty crucial testimony here because it kind of gives you an idea of how close she was to him. Now, of course, she's saying this was self-defense and that she was in fear of her life, but maybe the evidence suggests something else.
Yes, and so there was also prior testimony that the gun was on the table between the two of them very close together, and so it is an instant pick up the gun, fire straight in the face 6 times. So I do think they're two very different sides of the story, as we well know from opening statements about what happened in this case. She's saying she's a victim, but she opened fire 6 times right into the middle of his face.
Right. Now, Brad, I've worked enough domestic violence cases. I'm not saying domestic violence does not happen. Of course, we know it happens. But how can you then claim self-defense for 6 shots, one of those being in the face? That's a very up-close, personal, brutal crime. So it's hard for me to articulate that it was self-defense to try to get this individual off of me. What say you?
I agree. This is a nightmare case for the defense. There's no way around not only her 6 shots, last one into the face, regardless of what the distance may have been, there's still 6. We could justify 1, 2, even if you want to push a third, but then you have a 4th, 5th, and 6th. There's no way that you could justify that. Then she calls 911 and says, I killed my boyfriend, but it was 15 minutes after she shot him.
Right.
Or 10 or 15 minutes after she shot him.
It was several minutes after she shot him, and to your point, maybe the first shot, yes, that's the shot to get this individual off of you. The second, maybe even. I've seen people shot twice and it has no effect. So maybe you're right on that regard, but it's hard to say self-defense 6 times and 1 in the face. Let's go to the medical examiner here, Dr. Gregory Wagner, and let's listen to his testimony in the Shayna Huber's case. Okay, we just heard some pretty graphic testimony there from that medical examiner. He said that the victim in this case, Mr. Puston, was twitching. He had a severe brain injury, and again, of course, Shayna shot him in the face. That was the 6th shot. Still with me, Ashley Willcott and Brad Micklin. Ashley, I'll toss to you. I mean, that was pretty graphic testimony there from this medical examiner to give the jurors some idea of what really happened there. He had a severe brain injury, so that tells you how brutal the shooting was.
Absolutely. It also tells you that he potentially suffered between the first and the sixth shot. So he wasn't dead. He had a brain injury, yes, but he was having seizures, twitching, boom, 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 5 more shots. So really, it's a horrific death for this victim.
Yeah, I mean, that was very horrific. You know, one of the most tragic things I saw as a police officer was someone literally shot in the head, and I got to tell you, it's a sight I will never ever forget. Just the way I saw that body, you know, if I live to be 100 years old, I will never forget that. So I can only imagine what was there at the scene that day. Brad, let me ask you this. You just heard that testimony from this medical examiner, but she's still saying it was self-defense.
So that's where I wanted
defense on her part, and I guess it's just because her attorneys have nothing more. Her own 911 tape, again, she acknowledged and admitted he was alive. She said he was alive. I went around the table and shot him again. I think she even said to put him out of his misery. I hate to say it, she talked about him like he was an animal in the road.
Right.
And it's just horrifying that she's now going to try and pretend that she was so abused that she killed him. Because even, again, in that 911 tape, in her own words, she says, I was thrown against the couch, I think it was, or chair, but I wasn't injured. The responding woman on the phone even said, you were thrown into the couch but not injured? And she, again, admitted, no, I wasn't injured.
Right.
So she just took his life because she was upset or worried about something.
Yeah, absolutely. Well, let's actually hear Shayna Huber's side of the story. Let's listen to part of her police interview. Wow, so there is the police interview with Shayna Hubers. And one of the things I saw here, Ashley and Brad, was I shot him a few times because I didn't want to watch him die. And she talks about how she shot him in the head. She even talks about this nose job that he always wanted. So to me, it doesn't sound like this was really a case of domestic violence gone wrong, because even everything she testified before, that he was standing up, he was yelling, it doesn't mean you're an imminent threat against your life or serious bodily injury. Ashley, what say you?
No, all I could think of the entire time she was just giving this interview is not that she's a victim of domestic violence, but that she is angry and absolutely hates this man with a passion, so much so that once he's twitching, even I think a victim of domestic violence would call police and say, oh my God, oh my God, oh my God, I was defending myself, I shot this man, and now I don't know what to do, and he needs an ambulance. There's none of that. Instead, it's like this hateful, vengeful, I am going to keep shooting him until this you-know-what is dead. That's how it sounds to me.
Yeah, absolutely. Pretty gruesome testimony there, in my opinion. We'll have more of this just on the other side of this break. Stay tuned to the Law and Crime Network. Don't go away. Okay, thanks so much for that, Anthony, for those top crime stories. Before we get back to Shayna Hubers, I want to thank Ashley Willcott and Brad Micklin for joining me here on the Law and Crime Network. I appreciate your time, Ashley, of course, from Atlanta, and Brad here in the studio. Thank you so much. I appreciate it. Now, let's switch gears and let's get back to the Shayna Hubers case. Let's hear from a friend of the victim in this case who actually knew some pretty intricate details of the relationship between Ryan and Shayna. Take a listen.